Thank you. And there's also now, you have one other bill, which is file item 10, AB 548. Assemblymember Garcia, you're all set to present.
Thank you. In 2012, the legislature approved AB 1670 by Senator Laudernow, which amended probate code to remove the longstanding prohibition against non-resident heir beneficiaries being able to nominate persons they trusted, who are California residents, to administer the estate of relatives or friends who died living in California. AB 548 would simply remove the sunset clause from the provision probate code. AB 548 will make that authority permanent. The purpose is to continue to ensure that the families of deceased California residents can have a person whom they trust to respect the wishes of the departed administering his or her estate. With me to testify is Larry Doyle and Kieran O'Sullivan with Conference of California Bar Associations.
Thank you very much, Mr. Doyle. Good afternoon.
Good afternoon, Madam Chair, members. Larry Doyle on behalf of the Conference of California Bar Associations. The authors summarized the provisions of the bill very well. It came with a sunset clause. 3 years later, it has worked very effectively. As a matter of fact, staff, as indicated in the analysis, has researched it and found that the only case that has come forward since the enactment of the bill that would have been supports the continuation of this provision. It's something we've worked hard for a long time, and we ask for your support.
Thank you very much. Other witnesses in support?
Good afternoon, Madam Chair. Kieran O'Sullivan, a delegate to the California Good afternoon, Madam Chair. Kieran O'Sullivan, a delegate to the California Conference of Bar Associations, one of the sponsors and developers of the bill. Just want to clarify that this does not allow non-U.S. residents to become personal representatives. It only allows them to nominate who would become the personal representative. And since they can inherit, and very often sometimes do inherit the entire estate, there's no reason why they shouldn't have a say in nominating a U.S. resident to administer the estate. Thank you.
Thank you very much. Any witnesses in opposition? Any questions of members? All right, seeing none, thank you for pointing this out and bringing this bill forward. I think this is important for people who have interests in the United States, but they themselves may not be able to participate. So with that, Ms. Garcia, you may close.
I ask for your aye vote.
Very good. All right, we need a motion.
So moved.
Moved by Senator Hertzberg. It is due pass to the Senate floor. Madam Secretary, please call the roll.
Jackson?
Aye.
Jackson, aye. Morlock? Aye. Morlock, aye. Anderson? Aye. Anderson, aye. Hertzberg? Aye. Hertzberg, aye. Leno? Monning? Aye. Monning, aye. Wachowski? Wachowski, aye. 6-0.
6-0. We'll leave that on call. Thank you very much, Ms. Garcia. And next is item number 12, AB 879 by Assemblymember Burke. Good afternoon.
Good afternoon.
All right. I'd have to warn you, Senator Hertzberg is sharpening his blade. It is your first bill before this committee,
Yes.
And we're delighted to have you. If you'd like to proceed.
Yes. Thank you, Madam Chair and Senators. Our juvenile courts see some of the most troubling cases. They're bringing together social workers, foster care providers, law enforcement, children, and parents, all in an attempt to do what's best for our dependent children. The process is complex and usually involves a series of hearings, all of with different notice requirements for the parties involved. For decades, the system has relied upon first-class and certified mail, which parties with a stable mailing address has worked. However, for individuals without a permanent address, which is sadly common in dependency court cases, providing timely notice of hearings has been a challenge for our courts and our counties. AB 879 creates a voluntary program for county welfare agencies and the courts to provide notice to parties in dependency cases through email. All of the parties involved, the courts, the counties, and the individuals must agree to participate, and we've built in flexibility for courts to design and tailor their own system. While many individuals with dependency cases may lack a permanent, stable address, in most cases, they have access to a private email address that can travel with them and is accessible virtually anywhere. Keep in mind, all parties have to agree to the email notification, and for hearings regarding the termination of parental rights, notices must be sent first-class mail in addition to email notices. I respectfully request your aye vote.
Witnesses in support.
Good afternoon, Madam Chair and members. My name is Randall Harris. I've been with the Office of the Los Angeles County Council and Dependency Court since 1992. I'm here today on behalf of the Board of Supervisors for Los Angeles County, the co-sponsors, to talk about Assembly Bill 879, which, as you heard, would allow counties, courts, and individuals the option of utilizing email notice of juvenile court hearings. Since AB 879 is an opt-in program for the parties, there is no concern that people without email addresses will stop receiving paper notices. Instead, this proposed legislation will only lead to an increase in the number of people receiving actual notice of hearings and an increase in the protection of their fundamental rights to parent their children. By automating the notice process, we can help ensure uniform and effective notification of hearings. Therefore, we would urge your aye vote.
Thank you very much. Next witness.
Thank you, Madam Chair and members. Kathy Sunderling with the County Welfare Directors Association, the co-sponsor of the legislation. We think this is a really good way to move into this new approach, and that, as you have noted in the analysis, it's much more common now for people to start opting in to receiving electronic information in a variety of domains, including sensitive domains such as this. The protections are there to make sure that if the parental rights are proposed to be terminated, which is sort of the ultimate outcome of a potential juvenile court case, the notice would have to be sent in a mail form in addition to the opt-in email form. And it's permissive on the courts and the counties to get into the program in the first place, and then on any individual who's involved in the case to decide whether they would like to receive the notices electronically and then opt out if they decide that they wish to change. So for those reasons, we're pleased to co-sponsor the legislation and urge your aye vote.
Thank you very much. Next witness.
Madam Chair and members, Michael Radigan on behalf of the Board of Supervisors of Santa Clara County in support.
Thank you. Other witnesses in support.
Nicole Wertelman on behalf of the Ventura County Board of Supervisors, as well as the San Bernardino County Board of Supervisors in support.
Thank you.
Madam Chair, members, Juliana Voris with the Urban Counties Caucus here in strong support.
Thank you very much.
Michelle Gibbons with the California State Association of Counties, also in support.
Thank you. Any other witnesses in support? Any witnesses in opposition? Well, you've had more people in support of this bill than any of the bills we've had today so far, so congratulations. Questions by Senator Hertzberg.
Madam Chair, as I consider this measure, and I have a long list of questions for the Assembly member, I must make a point of personal privilege that I have a long relationship with both of her parents and knew her before she was born, so to speak. So given that, I'm going to pass.
See, there are benefits to...
Right.
All right, any other questions? Yes, Senator Morlock.
Thank you, Madam Chair. I think I should remind the body that the United States Postal Service is going broke. I can't believe you're doing this to the Postal Service. Thank you, Madam Chair.
Thank you. Of course, there are reasons the Postal Service is going broke that have to do with having to fund a pension plan 50 years in advance, unlike any other agency on the planet. But other than that, point well taken. Yes, Senator Wajkowski.
We're limiting this on notice for dependency cases in the juvenile courts. My question is why not allow in all juvenile matters, even in the criminal, since I would say our young kids are more inclined to receive an email, respond to it, that we've only narrowed it when it's a dependency challenge. Was there some?
I think, you want me to answer?
Baby step?
I think this is a process, and obviously there's prior legislation that has started this process, and I think we're just slowly moving forward with a comfort level in the electronic delivery. But you want to answer the question?
So if I may, the County of Los Angeles has a automated system which is in part doing email notices now in dependency court, notifying attorneys and Indian tribes pursuant to the Indian Child Welfare Act. So this is a natural extension of the process we've been successfully implementing in dependency court in Los Angeles County, and allows us to move into this arena with the hopes of looking at delinquency court in the future as well, assuming proof of concept.
Okay, and then I guess the other, it just sort of begs it when we still publish notice when we can't get in contact with folks. And, one would say the chances of somebody reading a legal journal to find out if they've been sued rather than going onto Facebook. I think people will at least, maybe once upon a time in the 18th century, people would go out in front of the city hall and read the notices. Right, but it just seems as you read through the analysis, if this is what the advocates are looking for is actual notice or people understanding what's going on, that may be a step.
In our future.
All right, Senator Anderson had a question?
I really appreciate you bringing this bill forward, and if you take any amendments, I'd like to be added as a co-author, and with that, I'd like to make a motion.
All righty, and Senator Hertzberg indicated if there were amendments, he'd like to be included as well.
Thank you.
All right. Senator Monning.
Just wanted to clarify with the author, children who are 14 or 15 years of age may consent to receive notification by electronic mail only if it is also accompanied by notice sent by regular mail. So part of your bill does protect the future of the U.S. Postal Service.
It most certainly does, and with certified mail as well, so we're doing our part.
Thank you.
We should remove that requirement that they fund their pension plan 50 years in advance, and I bet that'd be functioning rather effectively today. But that being said, that is added to the bill. Appreciate this effort, and there is a motion, and let's see, motion by Senator Anderson, and Madam Secretary, the motion is due pass to the Senate floor.
Jackson?
Aye.
Jackson, aye. Morlock? Aye. Morlock, aye. Anderson? Aye. Anderson, aye. Hertzberg?
Aye.
Hertzberg, aye. Leno? Monning? Aye. Monning, aye. Wachowski? Aye. Wachowski, aye. 6-0.
6 votes, and the bill will be on call. We have one member who's absent. Thank you very much. Our last bill is AB 987, file item 14 by Assemblymember Levine. Come on down.
Come on down.
Good afternoon.
Thank you, Madam Chair and members. AB 987 clarifies existing law that protects workers from retaliation or discrimination when they request a disability or religious accommodation. Current law requires employers to provide such accommodations. However, recent court decisions raise the question of whether the law fully protects workers from retaliation when a worker requests these accommodations. As a result, workers now too often keep quiet and are afraid to make such requests. Courts are dismissing cases where an employee alleges discrimination because the employee was fired or retaliated against for making a request for reasonable accommodation. AB 987 clarifies current law by explicitly prohibiting an employer from retaliating against a worker for requesting the reasonable disability or religious accommodation, regardless of whether the accommodation request was granted. The bill has no opposition. Here to testify in support is Minaka Fernando from the California Employment Lawyers Association and Alan Reinach from the Church State Council.
Thank you. Good afternoon.
Chairwoman and honorable members of the committee. My name is Menica Fernando. I'm an employment and civil rights lawyer in San Francisco. I'm here on behalf of the California Employment Lawyers Association, and we're proud to extend our support for AB 987. This bill is about making the law make sense. Currently, Californians have a right to a reasonable accommodation based on disability or religion, and employers are required to provide this right. But a court of appeal has recently said that if an employee asks for this right, they can be fired for it. The plaintiff in that case, Scott Rope, repeatedly asked his employer for leave to be able to donate his kidney to his sister, and his employer terminated him. The court said that even though Mr. Rope had the right to a reasonable accommodation, asking for that right was not protected, and he could be punished for it. This just doesn't make sense. That's like saying, as a woman, I have the right to be free from sexual harassment in the workplace, but if I ask for the harassment to stop, then I can be fired for it. This is not how the law works for sexual harassment, and it shouldn't be how the law works for disabled employees and employees who need religious accommodation. In my practice, I see employers getting a free pass because of this ruling. An employee who requested to recover from her heart surgery was fired just after making the request. Another employee was fired after 32 years on the job, shortly after returning from a medical leave. These employees are being punished simply for asserting their rights, and they can't bring a retaliation claim because of this ruling. How is an employee supposed to enforce her rights if she can't ask for them? The goal of equality in the workplace can't be achieved if employees are punished for asking for their rights. And it's common sense that people should be able to ask for an accommodation without fear of retaliation, without fear of being fired. I ask for your aye vote on AB 987.
Thank you. It doesn't sound like the court, one of the court's finer hours here. Sir.
Madam Chairwoman, honorable members of the committee, my name is Alan Reinach. I serve as Executive Director of the Church State Council, and we're proud to be a co-sponsor with CELA of AB 987. In our view, this bill seeks to reverse what is really a nonsensical rule that makes a distinction between those who complain about being denied accommodation and those who are respectful and quiet. We represent people of many different cultures, and different cultures have very different attitudes towards authority. And many of our clients would just be appalled at speaking out to an employer and accusing them of discrimination or of doing something unfair or wrong. And the ones who are the most respectful, because according to the Rope decision, they have not opposed discrimination, they're not protected against retaliation. Only the outspoken employees, I would be one of them. I'm from New York, and we're known for being obnoxious. So the obnoxious or outspoken ones, they're protected against retaliation, but those who are quiet and respectful are not. Now, I'd just like to draw your attention to an important distinction, because I've been litigating religious accommodation cases for 25 years, and it's important to understand the difference between an accommodation claim and a retaliation claim. If a worker requests accommodation, say, I'm Seventh-day Adventist for Sabbath observance, and the boss then relieves them of the obligation to work on their Sabbath for several Saturdays, and then decides, we're going to fire you. The judges will look at that fact pattern and say, there's no failure to accommodate claim because the employer did accommodate. They did let the person off, the worker off on their Sabbath. If, according to the Rope decision, we may not even have a retaliation claim either, if the person was being accommodated, they never had the opportunity to complain about failure to accommodate. So there was no opposing discrimination because the discrimination was the retaliation. So it's very important to preserve that. The EEOC has long preserved that in the guidance that they provide. This has been the law that we've understood for 25 years or more, both in federal law and in state law as well. So we urge your support for this bill that would clarify what we think has been existing law.
Thank you very much. Other witnesses in support?
And Greg DeGere, representing the ARC and United Cerebral Palsy California Collaboration, a coalition of people with intellectual and all developmental disabilities and their families, friends, and service providers. And it takes me longer to say that than to say that we support the bill.
Very good. Thank you so much. Next witness in support?
Raji Prasad from the National Association of Social Workers, also in support.
Thank you.
Dana Elneal with the Council on American Islamic Relations California chapter, and we're here in support.
Thank you.
Dennis Seaton, Church State Council, in support.
Thank you, sir.
Natalie Eva from the Church State Council, in support.
Thank you, ma'am.
Bill Gardner in Yuba City from the Seventh-day Adventist Church, in support of the legislation.
Thank you.
Aaron Briano, Esquire, in support of the legislation.
Thank you. Any other witnesses in support? Any witnesses in opposition? Any question from the members? No? Thank you for this bill. I think you did win, though, the number of people speaking in support, although it was close. But thank you for the measure. If you'd like to close, upon a motion by a member, we'll take a vote.
I respectfully ask for a motion by a member and your aye vote. Thank you.
See, magic. Thank you, Senator Monning. The motion is due pass to Senate Appropriations. Please call the roll.
Jackson? Aye. Jackson, aye. Morlock? Morlock, aye. Anderson? Anderson, aye. Hertzberg? Leno? Monning? Monning, aye. Wykowski? Wykowski, aye. 5-0 on.
5-0. We'll put that on call. Thank you very much, Assemblymember Levine, and all of you. That is concludes our items for today. We would like to, if we could get in the absent members all right, why don't we do this? We'll go through we're going to lift on the consent calendar. We'll go through the items once and hope we do. The only individual who I think missed most of the votes was Senator Leno, who is on the conference committee. Hopefully he's coming, but let's go ahead and no need for everyone to stick around unnecessarily. So, Madam Secretary, the consent calendar, all items to the Senate floor. Please call the absent members. Oh, I'm sorry. All right. The consent calendar, I've just been reminded not all of them are to the Senate floor, but they are on consent in this committee. So please call the absent members.
Anderson? Aye. Anderson, aye. Leno? Monning?
Is he the only one? We're going to replace the call on the consent calendar.
Okay.
All right, on those items that are on call, next item is file item 1. The vote count is 4-1. Chair voting aye. Please call the absent members.
Leno? Wykowski? Aye. Wykowski, aye.
All right, please replace that call. It is 5-2. 5-2. 5-1, excuse me. On the next file item is...
There's some Ross and Leno. Do you want to wait? And Hertzberg's coming down to vote on his. You are done, sir.
You're done. All right. And neither of the other two members who are absent are here, so we'll hold off calling them the roll and the items till they're here. And my understanding is, are they on their way? Thank you. Thank you.
Did Jamie go get Monty?
Yeah, right.
Sid, is it in my phone?
Members.
Leno, Leno, aye. Monning, Monning, aye.
Consent calendar is out. 7-0. All right, on the other items, file item 1, AB 87 by Assemblymember Stone. The vote count is 5-1. Chair voting aye. Please call the absent members.
Leno, Leno, aye. 6-1, that bill.
6-1, that bill is out. Thank you. The next item is file item 4 by Assemblywoman Cristina Garcia, AB 365. The vote count is 6-0. Please call the absent members.
Leno, Leno, aye.
All right, 7-0, that bill is out. The next item is file item 10 by Assemblymember Cristina Garcia, number 548. The vote count is 6-0. Please call the absent members.
Leno, Leno, aye.
That bill is out. The next item is file item 11, AB 807 by Assemblymember Mark Stone. The vote count is 5-0. Please call the absent members.
Hertzberg? Aye. Hertzberg, aye. Leno, Leno, aye. 7.
All right, that bill is out. The next item is file item 12, AB 879 by Assemblymember Burke. The vote count is 6-0. Please call the absent members.
Leno, Leno, aye. 7-0.
7-0, that bill is out. Next item and the last item is file item 14, AB 987 by Assemblymember Levine. The vote count is 5-0. Please call the absent members.
Hertzberg? Aye. Hertzberg, aye. Leno? Aye. Leno, aye.
7-0, that bill is out, and we are adjourned.